Good morning, class. In today's video, I will introduce you to the law of evidence and try to answer the most interesting question which intrigues most of the law students as whether law of evidence a procedural law or a substantive law. If we look into the classification of law, we find that law is classified into two categories. One is procedural law and the other is substantive law. Procedural law is also referred to as the adjective law. If we look into the digest of law of evidence by Sir James Stephen, he writes that substantive law is a law that confers powers and rights or imposes duties and liabilities on a person, whereas procedural law deals with the procedure by which these rights, duties, liabilities are enforced in a court of law. Sir James Stephen, who is also considered the father of Indian Evidence Act, further classifies procedural law into two categories. One is law of pleadings and the other is law of evidence. He says that law of pleadings determine the question in dispute between the parties. It helps the court to identify the fact in issue, the issues which need to be answered, which need to be decided by the court, and the second category being law of evidence, which helps the parties to convince the court to believe that their rights, duties, and liabilities, which they allege they exist. If we look into the legal regime that governs the procedural law in India, we have three major legislations. One is the Civil Procedure Code 1908, the other is Criminal Procedure Code 1973, and the Indian Evidence Act 1872. The first two codes, civil procedure and the criminal procedure, they determine what courts to approach depending on obviously the nature of the case, whether it is a civil case or a criminal case. So when it is a civil case, a civil court has to be approached, and when it is a criminal case, a criminal court has to be approached. Both these legislations also determine the jurisdiction of these courts. Whereas if we look into the Indian Evidence Act, which is also considered a procedural law or an adjective law, it talks about the production of oral evidence, documentary evidence, and material evidence, besides examination of witnesses. Indian Evidence Act, as we just discussed, it helps the parties to follow certain rules on the basis of which a court may be convinced to believe that their rights, duties, and liabilities exist. We can say that Indian Evidence Act is the exhaustive law. If you look into the uh, preamble of the legislation, it is an act to consolidate, define, and amend the law of evidence. But at the same time, if we look into the provisions that are contained in the CPC and the Criminal Procedure Code, we find that Evidence Act, though it is to consolidate and define the law relating to evidence, but it is not the exhaustive law that contains the whole corpus of rules of evidence. Just for instance, if we look into section 162 of CRPC, which talks about the statements made by any person to police officer during investigation, Such statements are barred from being proved before a court of law. Similarly, Section 306 and Section 307 of CRPC permit the magistrate to tender pardon to an accomplice for getting true and full disclosure of facts. This is again an exception to Section 24 of Evidence Act, which bars a confession made under inducement, threat, or promise proceeding from a person in authority. Also, if we look into chapter 23 of Criminal Procedure Code, the chapter is titled as Evidence in Inquiries and Trials. Similarly, if we look into CPC, it also contains provisions on admissions in Order 12. If you also look into Order 18, it talks about hearing of the suit and examination of witnesses. Besides, it contains several other provisions which directly or indirectly relate to evidence. Thus, we see that besides Evidence Act, there are other statutes also which contain certain provisions relating to evidence. However, the Evidence Act is a complete code in itself, and no judge can override the mandatory provisions of the Indian Evidence Act and admit an evidence which is not admissible under the statute. If we look into the illustration of a substantive law, for example, Indian Penal Code 1860 under section 302 provides death sentence. It is a substantive provision and it permits that death sentence may be awarded under certain circumstances. However, it does not provide the procedure, how it should be executed. The procedure is provided in section 354, subsection 5 of CRPC 1973. It says that the convict shall be hanged by the neck till death. Thus, we can say that substantive law and procedural laws both are interdependent on each other, and law of evidence is a substantive law. It's a procedural law. Besides law of evidence, CRPC and CPC, being procedural laws, they provide flesh and blood to the dry provisions of the substantive law. Justice Douglas observed, it is the procedure that spells much difference between rule by law and rule by whim and caprice. However, if we look, this being the theoretical difference, if we look into the statutes that are in existence in India, we find that it is difficult to establish clear distinction between substantive law and procedural law. As already discussed, we find certain substantive laws contained in the procedural laws and vice versa. We have substantive provisions present in the procedural laws, and at the same time we have procedural provisions mentioned in the substantive laws. And Salmond has also identified the same thing, and he says that it is not easy to state the distinction between substantive law and procedural law clearly because there has been an overlap in the present time. That's all. Thank you.